Once more, housekeeping issues, please mute yourself, close your micro, and please note that we will start the recording, or that we have started the recording of this session, and we assume that you agree to you being recorded as attendee and that you agree with uploading the video on the internet later. If not, you should leave this video conference now. Thank you. Dear friends and colleagues, ladies and gentlemen, good afternoon, good evening, good morning, depending from where you are dialing in. Welcome to this video presentation on the new German Court of Arbitration for Nazi-looted cultural property. Originally, I thought that this event would be a small thing to provide some information on an academic level in English, as it was requested a number of times. This is why there is no moderator, no panel, and to be honest, no technical support, etc. But we received more than 200 registrations from all over the world, which is absolutely fabulous. From Germany, of course, many from Israel, special welcome to you. Many from the United States of America, special welcomes to you. And also from Australia, Austria, Brazil, Canada, Chile, China, France, Italy, Korea, Luxembourg, the Netherlands, Poland, Portugal, Switzerland, Turkey. I hope I did not overlook too many others. Thank you all very much for being with us tonight. I would also like to thank the students of the University of Bonn who are with us tonight. As many of you know, we have been teaching the restitution of Nazi-looted cultural property since 2018, and we have expanded the program constantly, both within the curriculum of the law department as well as in the curriculum of the art history department, including now our joint interdisciplinary master program on provenance research and the history of collection. Thank you very much for being here tonight as well. A number of institutions, organizations supported us in setting up and promoting this event. The Arbeitskreis Provenienzforschung, the German Working Group for Provenance Research, the German Israeli Lawyers Association, the Art Law Center in New York City, the art law program at the Sigmund Freud University of Vienna, as well as the Dutch Stichting Claimants for Claimants. I think we have leading officers from each of these organizations with us tonight. Thank you very much for supporting this event and being here as well. But first and foremost, I would like to welcome those amongst you, the many of you, who suffered from the Holocaust and who took the effort to attend tonight. Thank you very much indeed for being here. Yesterday, on the day of the liberation of the concentration camp of Auschwitz in 1945, the 27th of January, there was the annual International Holocaust Remembrance Day. And many of us were involved in commemoration ceremonies and activities and thoughts about the Shoah. For example, today there was a ceremony in the German parliament where Thora Friedmann, a Holocaust survivor from Auschwitz-Birkenau, spoke to the parliament. And as many of you know, she works with her grandson on a TikTok channel to reach out to young people to tell her story and to let us know her history. And also tomorrow, if I may mention that at this point, there will be a talk here at the university with Gabriele Britz, who is a judge at the Constitutional Court, Federal Constitutional Court of Germany. And she will speak about the German Constitution of the Federal Republic of Germany as a kind of counter mirror image to the setup of the state as it was built during the Nazi time. And just to give you an example, that so many elements of our constitution today are a response to what we have seen in the past, that is federalism. Federalism has been made very, very strong in the new state as a response to totalitarian alignment of all levels of the state. And so we do have a very strong element of federalism in our constitution. And we sometimes criticize the complexity of going forward within this federalist structure. We should not forget that it is an answer to former totalitarian movements, and we will see how federalism sometimes impedes us in going forward. We need to overcome such impediments, obviously, but we should not forget where they come from. And also today, we should probably speak first about the Shoah and recall why we need to talk about restitution, in particular, the restitution of Nazi-looted cultural property. Since most of the audience are true and dedicated experts in the field, I will allow myself to start at a later point of this legacy. I will start directly with the Washington Principles on Nazi Confiscated Art, agreed upon by 42 states and a number of NGOs at the Washington Holocaust Era Assets Conference on the 3rd of December of 1998. And even in this respect, I will have to be very, very short, and I will confine myself to very few selected points to set the stage for presenting the latest from Germany. If you feel that there is something missing or that there is something we should point out in respect to the general context of the Shoah, please raise it in the discussion. If we look back to the Washington Principle and its core principle number 8, we are reminded that just and fair solutions should be identified expeditiously, recognizing this may vary according to the facts and circumstances surrounding a specific case. Stuart Eisenstadt, the spiritus rector of the Washington Principles, explained in this respect, after existing artworks have been matched with documented losses, comes the delicate process of reconciling competing equities of ownership to produce a just and fair solution, the subject of the 8th and 9th principle. I think we will see later on when we will go a little bit into the new assessment framework that will guide the arbitral tribunal in deciding the cases. We will see this difficult task of reconciling competing equities of ownership. If we go on and look again to principle number 11, nations are encouraged to develop national processes to implement these principles, particularly as they relate to alternative dispute resolution mechanisms for, as we heard before, resolving ownership issues. Alternative dispute resolution mechanisms. That's the plea of the Washington Principles. There is something that we could call, and that has been called, anti-litigation message in these principles. If I may refer once more to Stuart Eisenstadt, he said, and I think this is very right and hits the point, Principle 11 speaks to the need to give the other principles vitality. Procedure is of the essence, and dispute resolution mechanisms are of the essence to give the other principles vitality. There is one more principle on the procedural setting that we should strive for, and that is principle number 10. Commissions or other bodies established to identify art that was confiscated by the Nazis and to assist in addressing ownership issues should have a balanced membership. I think we agree on this immediately. It is a question, however, what does this mean in concrete terms? And we will see a solution that has now been agreed upon in respect, in particular, to the balance of the membership of the arbitral tribunal. Stuart Eisenstadt explained in this respect, to ensure objectivity and to enhance public confidence, these commissions should have members from outside the government, such as, amongst others, representatives of communities which were victims of the Holocaust. And again, we will see underway how the new Court of Arbitration for Nazi-looted cultural property has reacted to these demands and pleas in the Washington Principles. I will close this look back into the foundational texts, so to speak, by looking into the Washington Principles 2024 Best Practices, litera I, and we are reminded again of something that we've basically heard already just now. Countries are encouraged to create an independent expert body whose composition may be the state's responsibility, to which unilateral access is available, that can adjudicate cases of art and cultural property and arrive at or recommend a binding or non-binding decision. For example, the use of commissions in Austria, France, Germany, the Netherlands, and the United Kingdom. Such bodies should have balanced, expert, and representative membership. And again, there is the anti-litigation message. Use of alternative resolution mechanisms is encouraged to avoid litigation. Allow me to say at this moment that the United States of America are not really complying with this anti-litigation message in the Washington Principles and its best practices. Claimants have to go to state courts in the United States. There is legislation that tries to improve the legal situation, tries to overcome legal, formalistic impediments when filing their claims and when pursuing their claims within the regular state court jurisdiction in the court system. And that is, as many of you will know, tried to be achieved by the Holocaust Expropriation Recovery Act, in particular in its latest reformed version of 2025. If I'm still informed correctly, it's still pending in the Senate, but we expect it to be enacted and to enter into force very quickly. And then there will be certain technical defenses be removed, but still, of course, claimants need to go to regular state courts. There is no commission, there is no arbitral tribunal, there is no alternative dispute resolution mechanism available in the United States of America. This is different now in a different shape than before in Germany. And a first step towards this new development is a study on the reform and possible reforms of the former advisory commission. And many of you know, of course, that I had the privilege to be the academic director of this study that we conducted within a working group of 10 experts from very diverse backgrounds and different jurisdictions. And we delivered this study after a very short time that was given to us to work it out on the 28th March of 2024. And one of the options that this group developed was to set up an arbitral framework for handling the cases for Nazi-looted art. You can retrieve this document. It's 400 pages and it has an English summary. Under the link you can see here on the slide. I will share the slides with you if you wish after this presentation. It is not easy to retrieve it because, as you can see, the top-level domain is Kulturstaatsminister. At the time that we handed over the study, it was a female Kulturstaatsminister, so the top-level domain was Kulturstaatsministerin, and that was changed once a male commissioner came into the office, which kind of made it difficult for people in the international arena to still find the document. And I think that may be something that we should improve. What was the reason for the feeling that there is an imminent need for reform of the former dispute resolution mechanism under the or on the basis of the advisory commission? Well, there are a lot of reasons, considerations to be recalled. I confine myself to maybe the following. The first one was that there was no unilateral access. The parties, the claimant, the former owner, the pre-war owner, as the Washington Principles call this party, and the current owner, they had to agree on going into a kind of mediation procedure that could also turn into an adjudication procedure that would ultimately result in a non-binding recommendation. If there was no agreement between the parties, then there was no dispute resolution mechanism available. That was maybe the biggest problem in the list of problems that were identified. That was coupled with a kind of principle of subsidiarity, which meant that the parties first had to negotiate with each other about a just and fair solution. And only if that did not work out, only if the parties failed to agree themselves in bilateral negotiations on a just and fair solution, the advisory commission would be available. And that was mainly the reason why there were only more or less, depending on how you count, 25 cases handed down during the 20 or so years of work of the advisory commission. Don't please think that Germany has just cleared 25 cases since 1998. I think this misunderstanding is no longer around. There are thousands and tens of thousands of cases, restitutions that have been cleared, have been decided, objects have been handed over, but only very, very, very few cases ended up in the formal mediation procedure, in the formal dispute resolution mechanism. And this resulted in something that caused problems in relation to the development of the standards. I think a body, a central body of a country, has the responsibility and the task to develop standards, to interpret the rules of the framework that it works on, depending on which cases come in. And of course, if there are only 25 cases coming in over the time of 20 or so years, it is almost impossible to convincingly develop certain standards, measures that could help the practice outside the arbitration, the dispute resolution proceedings. In Austria, during the same time, the Kunstrückgabebeirat, the Art Restitution Council, decided more than 400 cases and managed to develop, in my eyes, a quite convincing set of standards, a grammar of reasons, so to speak. And that is something I think contributed to the standing and to the authority of the Austrian dispute resolution mechanism. That was not the case here in Germany. And the third and last point to mention is something that is, in my eyes, quite astonishing, and that is certain mistakes in respect to due process. I think even if it is a non-binding mediatory proceeding, it should be clear that certain principles of due process should be respected. I mean, this is a feature of any kind of procedure that is meant to produce just and fair solutions. So that is certainly another point that somehow created the feeling that there needs to be done something. Details can be studied in our report. I'm not going further into the details. At the end of the day, the 5 or so options that we developed included the setting up of an arbitral framework. And that is what you see on the internet now, as of 1st of December 2025. So a couple of weeks ago, basically, when the new institution started working. And you can see also the top level domain if you want to click on it later on if you're interested. There is not yet, if I'm not misled, an English translation, which will certainly follow soon, I assume, because that would be necessary for the international audience. And well, as you can see, the website is still somehow in a process of being built up. And I think that's going to be happening during the next weeks and months of activity of this new institution. Let me first of all highlight a few key points of the new dispute resolution mechanism. The first one is the following. For the first time, I think worldwide, claimants receive special legal claims, truly legal claims, not only political promises or moral expectations, but truly legal claims designed for the restitution of Nazi confiscated art under the Washington Principles. I would not be aware of any other jurisdiction that went so far in taking the Washington Principles seriously, granting specially designed legal claims. That is a commitment, I would say. The entire mechanism, that's the second key point, I would think, was negotiated with the Jewish side. And that was the Jewish side was represented by the Jewish Claims Conference and the Central Council for the Jews in Germany, Zentralrat der Juden in Deutschland. You see links underneath the titles of these institutions. And these links will lead you to the press releases in relation to the new arbitral framework. And both of these organizations express that the step towards the arbitral tribunal marks a significant step forward, is a significant progress, but and that is certainly something that we will be discussing later on. Both of these organizations and institutions also add and underline that for private owners, we will still need parliamentary legislation. And I can say already at this point, yes, of course, there is still missing out a piece in the picture to complete the task, absolutely. But still, the arbitral tribunal, the framework, marks a significant step forward. The claimant can now start the arbitral proceedings unilaterally, upon a standing offer by the holder. What is a standing offer? That is an offer to go into or to conclude an arbitration agreement with the other side. Would you please close the micro? Thank you. With the other side, and it is a standing offer because it is valid, it is meant to be valid for an indefinite time. So it is standing and it keeps standing out there and offers itself to an indefinite number of persons, all who are eligible for the new procedure are offered to accept this standing offer. And once the claimant, one claimant, a particular claimant, accepts the standing offer, there is the arbitration agreement. And the arbitration agreement then is the basis, the legitimatory basis for the entire proceeding that is enrolling from this moment. So the proceedings are not based on parliamentary legislation, but on an agreement. But the very important point to understand is that now the agreement is constructed, it is constituted in a completely different way than before. And the public holders, so the public museums, most museums in Germany are in the hands of public entities, they agreed on the political level to submit these standing offers. And once this is done, there is the same situation as if there were parliamentary legislation that imposes such a procedure on the respective public owners. You may say, well, that's a bit complex and somehow a little bit strange to my eyes. Yes, I would understand that. But let me add that this mechanism, standing offers from one side and then acceptance from the other side of a dispute, that is something that is very well known and very well tested over decades in international investor-state arbitration. Let me just explain the situation there. You would have a country, that's the state, and you would have a foreign investor who invests large sums on the territory of that state. And then the host state, so to speak, changes the legislation and thereby perhaps invalidates the foreign investment. That causes a dispute. I think we are very clear on that. The foreign investor remains free to go to the state courts of the host state. Yeah? But of course, we understand, I think, that the foreign investor does not feel really comfortable with the state court system of the state that invalidated the foreign investor's investment. So that is the reason why there was set up everywhere in the world investor-state arbitration by standing offers of the host state to go into a special arbitration proceeding. And the foreign investor, once he feels damaged by the host state, will have to decide, do I accept this standing offer or do I opt for other remedies, measures, procedures that may be available for me? You may recognize the similarity, structural similarity that we have in our cases. It is, I think, still a question whether a claimant feels good in the state court system of the state that has to take the responsibility for the Holocaust. And therefore, the arbitration framework offers the opportunity to build something up outside the regular state structures. And that is a chance to set up a structure that may convince us. The fourth central key point I would like to highlight is the following. We need arbitrators in this new arbitral framework, of course. And the new arbitral framework took a decision to work with a closed pool of arbitrators. This is rather atypical when we compare this with regular commercial arbitration. But I think we fully agree immediately that in our cases, we do not have regular cases in a commercial sense. It is a very special and sensitive thing that we are trying to cope with in adequate proceedings. So I think it was a good idea, and this is something we also advocated for in our study, that to close the task or being the arbitrator to selected people in a pool from where the parties then will choose their concrete arbitrators for their concrete proceedings. The pool of arbitrators was jointly selected by the Jewish and the German state side, 50% and 50%. And there is now a pool of 36 personalities. And you can see this list behind the link that is marked here on the screen. And also you will see at this pool, or when you look into this pool, that there are not only lawyers, but that there are also art historians, Holocaust historians, Nazi historians, Nazi time historians, and also, of course, provenance researchers, art history specialists. So it will be an interdisciplinary bench that will be composed by the parties together. And I will explain later on how this will work in detail. Next key point to understand and to evaluate the proceedings. The arbitral proceedings are conducted according to a specifically designed set of rules, the rules of arbitration for this court of arbitration for Nazi-looted property, Nazi-looted cultural property. At the beginning, when this model came up in the debate, some people misunderstood the idea and thought, oh, this arbitral tribunal will proceed according to regular procedural law, as it is the case in state court proceedings. No, this is not the case. There is a specifically designed set of rules of arbitration for this arbitration court. And we will, of course, later on go a little bit into the details of these specific rules. Likewise, the claims that are to be assessed by the arbitral tribunal on the basis will be assessed on the basis of a specifically designed assessment framework. That's called the assessment framework. Again, at the beginning of the debate, there were misunderstandings, and people thought, oh, the arbitral tribunal will decide the cases according to the standard German property law, which would have been absurd, of course, because the German standard property law is not designed for the very specific cases that are in front of us, and the Washington principles have been set in place to overcome the applicable property law in the respective jurisdictions to get to better and more adequate rules for our cases. And of course, also in this framework, there is a very specifically designed assessment framework. Last point on the list of the key points, and I invite you to maybe refer to these points later on in the discussion if you would like to know more about it. I welcome all of your questions. Last point in the list of these key points, the entire setup is based on legally binding agreements between all levels of the state of the Federal Republic of Germany. That is called technically an intra-federal administrative agreement. It has the status of an international treaty, but it's of course not an international treaty because it's not a treaty between, let's say, Germany and Austria or Germany and the United States of America, but it is a treaty between the states of the Federal Republic of Germany plus the federal level itself plus the municipalities. So it is again, an element of taking the Washington principles seriously. I'm not saying that this is not that was not the case before, but we have to note that before everything was based on political, legally non-binding agreements. And now there is legally binding force in the underlying instruments. And I think that is also an element of progress. Please note that our study brought up the idea, developed it, and tested it, whether it is at all feasible within the legal framework that we are operating in. Yes, that was the study that developed this idea, but when it came to the stage that the political units negotiated and developed the rules of arbitration, the assessment framework, and also the administrative agreement, I was not involved. So I am now, in the next slides, I am now with you. I will go with you into these texts and try to understand them to see what will be the contents of these rules. Yeah. Before we do that, let me underline once more in my view, very positive detail, and that is that the government now provides all these foundational documents that I mentioned, and in German that would be Grundlagendokumente. All these foundational documents are available not only in German, but in English, French, and Hebrew. And you can download them from or underneath the link that you can see here on the slides. Okay. Now, I will go through these foundational documents and I will highlight certain points very briefly, of course. So there was just one slide for each of these foundational instruments in order not to overload this lecture. We would need days and weeks, I would guess, to really understand all the details. And maybe even then we would not understand all the details. So that's going to be a process of deliberation and discussion. And I understand this lecture also as a kind of starting point towards this discussion with the public. And again, I invite you to raise all your questions later on. This is a very important process of inclusion of the public to understand what we are talking about. So let me start with my few points on the administrative agreement, the intra-federal treaty between the units, the entities within the federal state. There is a preamble that clearly and unconditionally acknowledges the responsibility of Germany for the restitution of Nazi-looted cultural property. This is important, I would say, because the instrument, the administrative agreement, is a treaty, a binding treaty. And of course, it needs to be interpreted. And whenever there is a question of interpretation, the preamble provides for guiding principles to clarify certain points that might be not clear at the outset. So I think such a preamble is of importance. And we also advocated for such preambles in our study. Standing offers by all the state entities are agreed upon in this administrative agreement. And this relates to each and every entity, public entity, that holds cultural property as an owner. Because the idea of the arbitral framework is that there is no legislation imposed by the federal legislator upon the states, upon the municipalities' property, which would have been difficult, possible, but difficult and constitutionally delicate. But under this structure, each and every owner, public owner, decides by itself decides itself whether to participate or not. And of course, these entities are now bound in the treaty to this standing offer. This includes the Federal Republic of Germany plus all 16 federal states. So they are directly bound in the administrative agreement to their standing offers. So these standing offers are out there, they are valid, they can be used by claimants. Another thing is the municipalities. The municipalities are represented in the administrative agreement by their umbrella organizations. That's the term, the technical term. There are umbrella organizations for the 10,000 or so municipalities in Germany who are parties to the treaty. And they promise in this agreement to do their utmost to convince all their member municipalities to also issue such standing offers. But since these representative umbrella organizations do not have a power of attorney for their municipalities, they have still to kind of encourage and motivate the municipalities, the cities, and other entities underneath the level of the states to issue such standing offers. And to facilitate this, there is a template by the government for these standing offers. And if you go into this template, I think it's not available in English, unfortunately. It includes, and I think this is really an important point to note, it includes all cultural property of the holder, all cultural property of the holder, if the holder is the owner, that's the condition. But everything that is owned by a city, for example, and its museums, that would be included by the standing offer. There is also a template for accepting the offer. So a claimant does not need to formulate itself such a standing offer, not standing, a response to the standing offer, but is invited to use a one-pager, needs a signature, and it can be sent back to the office of the arbitral framework. And then that's all that needs to be done by a claimant. And that is the moment where the arbitration agreement is concluded by the claimant. Now, let's look at the numbers on the level of the municipalities. I hope I counted the number correctly as of today, a little bit beyond 200 of the of holders submitted their standing offers. This is, of course, not yet satisfactory. And I must say, I would have hoped for a larger number of participation, absolutely. I would think that many municipalities are still in the process of getting these standing offers through their local parliaments, which is necessary for constitutional reasons, and that there will be a growing number of standing offers soon in the future. But we will see how things develop. That's what we made very clear in the study. The price for this arbitral framework is that each and every public owner submits such a standing offer. Otherwise, it will not be complete, so to speak. And the advantages, I think, are clear compared to the complexities of a federal legislation. Yes, but there is also a price to pay. And there is still some homework to do for the municipalities. Now, I think we have to nuance this quite disappointing number a little bit by the following. When I see the list, I think that quite some of the big players are already in the system. Munich, Cologne, Düsseldorf, my city, Bonn. They're all in the list. And it may not be the most important point that a small village somewhere out there in the landscape, without even having a museum, participates in the system. So that is one thing that we should take into consideration when we evaluate this state of things. And the second point maybe is even if the system will not be entirely complete at the end, it still offers, by including the participating owners, so much more than there was before. And I think that is also something that we should need to take into account. But again, there is quite some homework to do for the municipalities. Let me tell you one, not anecdote, but experience in talking with cities and museums. We had a presentation on the topic at the Kunstmuseum Bonn, the Museum of Bonn, the City Museum of Bonn. And I explained these things there, and the director said, yes, we discussed this, and we felt a little bit uneasy because after submitting the standing offer, we will have given up our sovereignty. And I said, yes, exactly. That's what we expect you to do, to give up your sovereignty because you give it into the hands of the arbitral tribunal. And this is exactly what the system, what this framework intends to achieve with every public holder. So it might take some time. It might take some more time than we had hoped for at the beginning. I am still quite optimistic that at least the relevant owners will participate at the end. If nevertheless you are a claimant and you see on the list of participating owners the museum that you want to address is not part of the system, the service desk of the arbitral framework will urge this city for submitting the standing offer. So there is a procedure that specifically addresses this situation. And of course, we expect then at last the public owner to offer to declare the standing offer. Okay. Number three, there is reference even in the administrative agreement to the overall normative or moral architecture. And that is the Washington Principles, of course, of 1998, the Joint Declaration, the first document that implemented the Washington Principles in Germany by a non-binding political agreement, Terezin Declaration 2009, Best Practices 2024. So all of these international surrounding non-binding normative texts are referenced in the binding administrative agreement. And I think this will also help getting the things into the right direction. You may have asked yourself already, what happens if someone wants to terminate this administrative agreement? Well, the rule in the agreement is that termination is excluded for the first 5 years. And even afterwards, there would be a time limit of 2 years towards the end of a calendar year that it will take to go out. Yeah. Even if someone goes out, the rest of the participating states will remain bound by the treaty, by the agreement, until a certain minimum level when it doesn't make sense anymore to uphold the system if everyone goes out. That's a different thing. But this is excluded for the first 5 years. And so we have some reliability by this binding treaty. And you may say, well, that is not so much reliability. It's not that much reliability that I would wish for. Yes, I would understand this point. But don't think that a parliamentary legislation would have been more reliable. I think we all have the experience that parliamentary legislation can be changed very, very quickly. We have examples from other areas. I'm not going into details here in this lecture. It's very easy to change a legislation. Once the majority is a different one, there will be things that may change. And so my perspective on this choice between administrative agreement as the foundation or federal parliamentary legislation is that this administrative agreement might be more resilient even than a parliamentary legislation. But that's, of course, a matter of prognosis and a matter of evaluating certain risks. Yeah, that's for sure. Last point on this list, there will be an evaluation after 3 years or the first 10 arbitral awards. Yeah, that's something we also advocated for in our study, because I think it is very important to criticize constructively what is going on, what we like, what we appreciate, and what we may want to improve. And 3 years is not very much time, and 10 arbitral awards is not very many. So I think we are well advised to already embark together on this process of evaluation. And in a sense, I understand this lecture and your participation as a kind of start for this process. And so again, I hope for your critical questions. I would be very, very happy to receive your thoughts per email or otherwise later on. Whatever you see, share it, and then that will give us the opportunity to prepare something for the moment where there is the official evaluation. I am in communication with a number of institutions, organizations to kind of organize a kind of academic process of evaluation. This is part of it, and I think we all should take the initiative in evaluating what we are seeing. Okay, so that's the few points on the administrative agreement. I will go on now with the rules of procedure. First one, that's the one you know already, and that is, again, a very, very clear and unconditional acknowledgement in the preamble of responsibility of Germany for the restitution of Nazi-looted cultural property. The next one is on eligibility. So you will want to know who is eligible to go to the arbitral tribunal. And of course, it is everyone or the heir who raises a claim for a loss of his or her cultural property due to Nazi persecution between the 30th January of 1933 and the 8th of May 1945, on condition that the object in question is located in Germany. So that will raise a number of questions from your perspective, I guess, because immediately you will think, what happens if a museum removes an object abroad? Theoretically, this is possible. Politically, I would be very astonished to see this really. I don't think that this is a real danger, but we will see. It is maybe more interesting to think the other way around. Is it possible for perhaps private parties who somehow negotiate bilaterally on an object that is, let's say, located in the Netherlands, somewhere else, to get into the arbitration framework here by moving it to this territory? That is something we do not have an answer in the rules. So I cannot give you really a definitive answer on this question. I don't see any problem in saying, okay, the object is now in Germany, so please let's go to the arbitral tribunal. Yeah, that's on the territoriality of the dispute resolution mechanism. Next point, on the level of the rules of procedure, and that is again a few words on the pool of the arbitrators. As I said, there are 36. There is a president, there is a vice president, and 34 other people. The president is Peter Müller. who has been a leading judge at the Federal Constitutional Court, and before he was the prime minister, the governor, so to speak, of one of the German states, Saarland, and someone who has handled the most difficult cases from all contexts on the constitutional level, I think, is capable of handling our cases properly as well. So that is, to my mind, a promising choice. And the vice president is, you may have noticed that, Elisabeth Steiner. Elisabeth Steiner is an Austrian citizen, and she was, for 2 terms, a leading judge at the European Court of Human Rights in Strasbourg. And again, I would say, if you have handled cases that touch upon ourselves as human beings, human rights, you are very well prepared for the type of cases that we are supposed to deal with in this system. And you may have a look at the 34 other people in the pool. How now do you compose the concrete arbitral bench for your case? This is going to be as follows. There will be a bench of 5 arbitrators at the end. So you, as a maybe claimant or maybe holder, you will choose 2 out of the pool, 1 qualified as a lawyer and 1 qualified as an historian, Holocaust historian, or provenance researcher. So it's 1 + 1. And the other side is doing the same. And these 4 arbitrators will then agree on the 5th and presiding arbitrator. Now you will ask, what happens if these 4 do not come to an agreement? That is regulated by the framework of arbitration law in Germany in general, and the state courts will substitute the agreement by appointing 1 person from the pool. So it is not the risk out there that the process of composing the bench will end up in a deadlock. Yeah? The German state bears the costs of the arbitral tribunal. The arbitrators will be remunerated. That is something that we advocated for in our study because it is a difficult and time-consuming task that we expect them to fulfill. So there should be a remuneration. You can read in the foundational documents how much this is, and that is 10,000 per arbitrator per case and 12,000 for the presiding arbitrator. Now, some people said, oh, wow, this is so little as a remuneration. This will crash the whole system because there will not be any qualified people out there who would go into the pool. Others said, wow, this is a large sum and it's not really appropriate to remunerate people with this task to this level. So that's a matter of discussion. I don't know your opinion on that. It is now 10,000 or 12,000. So please note, it is 52,000 euros per case that the state, the German government, pays for each proceeding. It does not pay for the lawyers as it was before. That's nothing new. Some people were surprised that there is no coverage of the legal fees of the parties. Well, that was the case, was not the case before, and it's not the case now. The award will be publicized, and one of the elements that is supposed to take care of the nature of the cases that we are supposed to deal with is that even if there is a negative award, sometimes there will be cases where the arbitral tribunal will say, no, this is simply no case for restitution because it was the object of someone else. Even then, the arbitral tribunal is obliged to note precisely, like a court, according to court standards, the fate, the history of the persecution of the person that whose property seemed to be in question for this proceeding. And I think that is also something that contributes to the task of remembrance and documentation of persecution and the mechanics of persecution by the Nazi regime. The arbitral award has the same status as a court judgment, so it is enforceable by law. There will be a limited review by a setting aside proceeding before state courts. That was also a very strong demand in the discourse towards the arbitral system that there should be a review. It is anyway a review in the arbitration legislation that surrounds our arbitration framework. Yeah. So we will have this review now as well. Before, there was no review at all. Another very important point, I think, is that the parties or the arbitral tribunal will always encourage amicable settlements. And the parties are at all times allowed and encouraged and invited to settle the case in a certain way. So going into the proceedings does not mean that you are excluded from settlements. Last point, or second before last, on this list on procedure, there is a 20 months period for a preliminary proceeding in which the parties are supposed to bilaterally negotiate their case before the actual arbitral proceedings can begin. Now, you could be critical about this. I was very critical about this preliminary proceedings, but political decision was that this should be part of the dispute resolution mechanism. A technical question now is, when do the 20 months start? Do they only start as of 1st December 2025, or is it possible to count the time before the 1st of December 2025 when the entire mechanism entered into force? I would strongly advocate for taking into account a 20 months period that took place before the 1st December of 2025, because I know cases where the parties were negotiating for years already. Why should they wait again 20 months? I would not understand the logics of this approach. Last, a little bit more complex slide, and then we are going into the discussion, and I'm looking very much forward to your questions. And that is now on the assessment framework. Again, the preamble, I don't think that I need to say anything anymore on this. Second point, applicability of the assessment framework. It has been applied since 1st of December 2025, and that includes not only the future arbitral proceedings, but also already the public holders in their bilateral negotiations. And this is explained and further explored, so to speak, in the new version of the government's manual, the Handreichung, that just came out recently in 2025. How about the standing? That is the question, is it the right person, the right party that raises the claim? Of course, it is the former victim of persecution and his or her heirs, very clear, no question there. But in case of a community of heirs, it seems to be the case that all of the members have to be on board. Yeah? That's a problematic rule, if you ask me. And in our restatement, we developed a different approach where we said communities of heirs are usually spread across the world, and they hardly ever agree on how to proceed. So we need another approach, and that would be to perhaps restitute to the present members of a community of heirs, but if there is restitution, oblige the present members of the community of heirs to develop a just and fair solution with the non-present members of the community of heirs. Here it's more formalistic in that all members are required to be present or represented by a power of attorney. That's going to be difficult in a number of cases, but it is in line with the best practices of 2024 for the Washington Principles, where it's also the rule that restitution should go to all beneficiaries of a community of heirs. And that's probably to be read as saying only all beneficiaries. There is no good faith defense. There is no acquisitive prescription. There are no time bars. I think this is important to note. That's something the HERE Act of 2025 tries to build on and tries to improve the applicable law in the United States. No such need here. All of this is excluded. There is a reduced standard of proof, for example, for the question whether the victim was, in fact, the owner at the time of the loss. And there are certain presumptions of ownership based on actual or former possession of the object. So first thing to note is it's not the regular civil property law that applies, but it is a special regime that applies and that operates on the basis of reduced standards of proof. So for example, for the ownership question, it is only necessary to prove this with a high likeliness. That's the same standard like in the Netherlands, in the Dutch assessment framework. And it is reduced from the standard of proof that you would regularly have to achieve and comply with in state court litigation. Maybe more important, there is a presumption of ownership based on actual or even former possession of the object. That's a big step forward compared to what we had in the rules before. However, this is limited, or this is not extended, this kind of privilege, if you like, to commercial commodity in the hands of a dealer. And some people said, oh, dealers are now disadvantaged by the new assessment framework. I think we cannot really say that because there is a new privilege that was not extended to dealers for good reasons, if you ask me. So that is the situation that we should discuss and evaluate, not the isolated statement that dealers are somehow disadvantaged. I think that is distorting the real nature of the rules. There are special and favorable rules for the victims and the claimants for objects as collateral to secure a loan. I will go into details if you wish in the discussion. There are far-reaching presumptions of a loss due to Nazi persecution in case of forced sales, except for the case of flight-related sales, sometimes called flight goods. Some people said, oh, the new rules are disadvantaging the claimants in respect to flight goods. No, this is not the case, because before we did not have a presumption at all in respect to flight goods. That was one of the few things that you could read from the practice of the Advisory Commission. So you could not say that in this respect claimants would be disadvantaged by the assessment framework. So there are other things that we might wish to criticize, but I think this critique is unfounded. If there is a case for restitution, the primary remedy will be restitution. Certain modifications are envisaged by the assessment framework. One point is important to understand. Direct compensation is not available. Direct compensation means that the arbitral tribunal says, well, there is a case, but there are certain problems in the case, maybe evidentiary problems. So an adequate, just and fair solution might be 80%, 50%, 30%, 90%, whatever the arbitral tribunal believes to be just and fair. We see such solutions in other jurisdictions, Switzerland, France. They are not available here in Germany. I think that this is not optimal. I think we would need this solution, this possibility of handling cases here as well, but there seems to be no budget for it. Maybe we can change this somehow in the future. Now, I have a few questions here to wrap up. I'm very much behind my time. I thought it would be much quicker to go through these points. I think I will skip these questions, except for the last one, the fifth one. Will now the world be perfect? I think you know the answer to this one. And it is clearly no. After the Holocaust, nothing will be perfect, and nothing is anyway as it was before. Maybe, and that would be the hope, the new framework will improve the situation. Of course, each and every approach to dispute resolution has its pros and cons, its benefits and prices, and it is always necessary to discuss this relation of benefits and prices, of pros and cons in an open academic debate, discussion, discourse. And I think I would very much like to start this discourse now with you. I took a lot of time. I apologize for that. I will be the last one to leave this session, so don't be concerned that you might not be able to pose your question. What is the rules for posing questions? Please raise your electronic hand. You will find in the buttons down here at the bottom of your screen a button that says reactions. And one of the reactions offered there is raising your hand, your electronic hand. And I will simply follow the list of hands that I can see in my list here. And that's the way we go through the questions. And I would very much like to ask you to open your cameras as well so that we can see each other when we are talking with each other. Thank you very much. First question by Alfred Fass, please.
Thank you. I'm sorry about my voice. I'm sorry. I'm a little bit problematic at the moment. First of all, Professor Weller, I wanted to thank you very much for this real tour de force on German arbitration in cases of looted art. We are all deeply grateful for your long-standing and unwavering commitment to restitution. As one of the heirs of Abraham Adelsberger collection, I would like to ask you a couple of questions. In August 2025, we received confirmation that a major painting from the collection was located in Nuremberg. The current holders, a well-known private family with roots in Fürth predating the Shoah, have formally acknowledged that the painting is in their possession. Since August 2025, their lawyer and our legal representatives have been in correspondence. However, after more than 6 months, there has been no substantive progress. The Holders Council continues to request additional and ever-expanding proof of Adelsberger's ownership, despite extensive existing documentation. The DZK project about the Adelsberger collection. So, two questions. My first question is, under these circumstances, is it possible for the heirs to unilaterally bring the case before the German Arbitration Commission for Nazi looted art? And if so, would the Commission be likely to accept and examine such a claim without the consent of the current holders? And I would like to add one other thing. I understand that all the heirs have to agree to arbitration. Now, if 25% or 20 or 10% of the heirs do not agree to arbitration or cannot be found. What will happen with arbitration?
Thank you. These are very important and central questions. The first one relates to a case between, or the two of the questions relate to a case between private parties. So you rightly direct our attention to the fact that the arbitral framework is designed and is operated for and by public owners. And only if there is a standing offer or at all some kind of offer to go into arbitration, and that offer is accepted by the other part, the claimant, there will be arbitration. That's a fact that we cannot transcend and that we cannot remove, even though we might wish to, because we need the consent from both sides. As long as we do not have a parliamentary legislation that imposes upon the owners to go into a proceeding. So I don't see a possibility to force a private party into the arbitral proceedings. Maybe there are considerations that you could share with the other part to nevertheless consider arbitration, because the state is offering a bench of 5 arbitrators that are probably highly qualified and neutral and somehow dedicated to the subject matter. That's at least what we expect from the people in the pool. I think that you, as two private parties, can agree on certain modifications in the proceedings. For example, you might wish not to have the award published afterwards. So you could do this, and you could introduce other elements of your choice. That's the big strength of arbitration, that you can change things. The public owners will not change things because the standing offer as it is issued is based on these procedural rules and the assessment framework. So that's fixed, and that is stable, and it's not open to arrangements and changes. But that might be different for private parties. And at the end of the day, I think we need the parliamentary legislation for private owners. That's something the current government in its coalition agreement promised us to be enacted soon. The coalition agreement promises an effective restitution act for private property. And of course, we hope that this is going to be happening soon. I can tell you that we also accompany the process, the discourse, the academic discourse on this level here in Bonn. There is a dissertation currently underway, and it's almost completed, on how such a restitution act could look like under constitutional aspects, under other aspects. And I'm very excited about this piece of academic work, and it might perhaps help to bring this restitution act about. That's my answer. I hope it is satisfactory for you for the moment.
About the heirs, if
The
they have
heirs,
not,
yes,
yeah.
yeah. Well, the heirs need to be complete as far as I read the rules, but that is in conformity with the best practices. I think it is litera I. I would have to look that up, but it says it should be restituted to all beneficiaries, and that would mean to all beneficiaries. And if you don't have all beneficiaries in front of you or represented by a power of attorney, there is not all beneficiaries, which is a big problem. And that's why I've always advocated for an alternative solution, and that is, let's settle the case with the present members of the community of heirs, but oblige the present members of the community of heirs to agree upon a just and fair solution in respect of the object with the other non-present members of the community of the heirs. And then I would think that such issues like who invested in the case, the time, the money, the provenance research should play a role how this just and fair solution looks like. But that's just a theory. That's just a proposal of mine. It's not what is in the rules. In the rules, we need all beneficiaries of a community of heirs. Thank you. If I may go on, that's the next one on my list is Stacy Jessamine, please.
Thank you, Professor Veller, for organizing this. It's very, very interesting to be able to hear all these perspectives. So I'm a lawyer and academic in North America, in both Canada and the United States. I also worked as an arbitration lawyer for just under a decade in Paris. So this is all very interesting to me. I have two questions. One relates to the legal costs. You've said, and I understand the parties have to pay their own legal costs. Correct me if I'm wrong, but I think about 50% of the 25 or so 24 cases decided by the Lumot Commission were decided in favor of museums. So I'm wondering if there has been any initiative or any state funds available to claimants to support their legal costs and legal fees, basically, because I understand the procedure is provided by the state. But and then do the costs of handling the legal cases, the human resources, the legal costs of the museums come from the operating budgets of the museums, or is there funding provided to museums? That's the first question. The second question is, so if a painting is loaned to a German museum from an institution outside Germany, can the museum still, German museum, take legal steps to ensure it won't be seized? Are those steps still available, or does making a standing offer force the museum to abandon that right? Such that the claimant could bring a claim for restitution once the painting enters the German museum.
Thank you, Professor Jessamine, for these two very good questions. I start with the second one, and that is the loan. If an object comes to Germany by way of a loan, it is not covered by the standing offer of a museum, of a receiving museum, because the standing offer only extends to those objects that are the property that are owned by the museum. And that is obviously not the case in respect to loans that come from outside. So that would be the standard situation in terms of loans. On top of that, there is, of course, an anti-seizure legislation in place, like it is in some states in the US as well, and also on the federal level, and I think even in Canada, but correct me if I'm wrong on that. So there is the possibility to protect loans against seizure. But I think it would not be necessary in respect to arbitral proceedings in this framework, because the standing offer does not at all extend to objects that are not property, that are not owned by the museum. I think that was more or less the first question. The second question, and the first question is on legal fees. Yes, that's a big problem. At least the costs of the arbitral tribunal, and these are quite high, as we have seen, are covered by the general budget of the participating federal level and states and municipalities jointly. Yeah? So that's out of the balance sheet for the parties who run or try to raise a claim in arbitration proceedings. Okay, there is the question of the legal fees for the party representatives. There is no legal aid. There is no special fund that is provided. That was the case before as well. The usual solution is, of course, that the lawyers work on contingency fee basis, as you know it from the United States of America. There is a problem with that as well, as you may know, because contingency fees are not legal in Germany. But that's maybe a problem that is a theoretical one. The practice, as far as I can see it, is that the lawyers work on contingency fee basis. That might not be optimal because of a number of reasons, because the object will have to be sold afterwards, but probably it is anyway to be sold because there is often the community of heirs. And that's where we are standing at this moment. There is no special fund that would help covering the costs of legal representation, nor the costs of the provenance research conducted by the parties. But there is, of course, a quite large program with the run by the DZK, the German Lost Art Foundation, to help claimants, victims, and their heirs to assess the status on the level of provenance research of the objects in question. So that is the way the German state seems to help the claimant to establish the case. Yeah. Does that answer your question sufficiently?
Thank you very much.
Thank you so much. The next one on my list of electronic hands is Carol, please.
Thank you very much. And thank you very much for your very erudite explanation to Stacey's questions. In fact, my question was her second question. As a provenance researcher, I had been hoping that if it was affecting those that were loaned, that a little bit more provenance research would be done by museums for those of us who are researching certain paintings.
Okay, thank you very much, Carol. That was a comment as far as I understand, and we should take this into consideration. I should maybe mention that the coalition agreement of the current government also says that provenance research should be increased and supported. I think that's what all the coalition agreements said in the past, and it was not always the reality to the extent that we would wish to see it supported, but at least it is politically agreed that provenance research should be increased. And I should also perhaps add that the arbitral tribunal is, of course, entitled to conduct provenance research on its own account. That is a capacity of the arbitral tribunal to investigate the case itself. Yeah, that's different in state courts in civil proceedings, where a state court would not investigate itself the case, but this arbitral tribunal is empowered to do so. And I understand the rules as saying, well, these costs are costs of the proceedings of the arbitral tribunal. So these costs are covered by the public budget as well. So we will see perhaps more case-related provenance research that is directed to very specific points within the assessment framework. And that's something I would welcome, but it should, of course, not cut down the budget for the general provenance research within the institutions. That's, I think, also very clear. Thank you so much.
Thank you. Thank you.
Iris.
Hi there. Well, it should be Tabitha.
Tabitha, yes.
I have some problems with my Zoom features. But dear Matthias, it's really good to see you again. Thank you for your insightful presentation. I do not want to impose too many questions, so I'm going to try and keep this very short. First, I saw in your sheets that you made a reference to your study on the Beratende Commission, and I think you mentioned something about that. I was just meaning to ask, as from my capacity as a researcher, it is rather difficult to get access to the document since I think a month or so. Do you have any idea when and that document will be published again, or at least easily accessible?
Thank you. That's a very good question. We would love to see it published as a proper academic book, to republish. I mean, it's somehow published as a PDF that is somewhere in the archives of the Federal Commissioner for Culture and Media, quite down somewhere in the system of these websites. And of course, you can Google it probably and hit it somehow. We, as the working group, and it was an excellent working group, and according to the registrations, I think there must be a few of our excellent working group members with us. I think I speak in their sense and on behalf of them as well. If I say we would like to see it published as an academic book, to have it available in libraries, maybe also online open access. The government has not consented to it. It's their study. They commissioned it. Maybe we'll have a new round on that in some time. But at the moment, it's only available as a PDF somewhere deep down in the internet.
Yes, well, it was indeed very deep down. So I had a lot of trouble finding it.
Yeah. Thank you for giving this
So
information. Yeah,
yeah,
thank you.
and I think that as an academic researcher in this field, we want things to be as transparent as possible. And scientific or academic studies like these are elementary to make an informed argument about anything.
Yeah.
So then I'll go to your sheets. You had a sheet called Some Further Points on the Assessment Framework. I'm looking down because I'm trying to read from some pictures that I made. And I saw that there was a point 6 where you mentioned special favorable rules for objects as collateral to secure a loan. So I was wondering, since my primary study object has been the Dutch Restitutions Committee, they have long rejected the possibility of considering those claims that consider a collateral. So I was interested in how those rules evolve in the German context.
Thank you. That's a very, very important question because I think the rules laid down now are really, I don't want to say revolution, but they are nailing down a very, very favorable position for claimants in these constellations. And we need to distinguish between the constellation where the victim, the persecuted person, the Jewish person, handed over, for example, to a bank an object of art as a collateral to secure the claim for repayment of the loan granted by the bank. And we have a number of cases where this happened in, let's say, 1930, 1931. And technically speaking, in such a situation, the loan taker hands over the property, transfers the property to the bank, and that was reason to argue, well, the property was lost in 1930, 1931, so it's outside the time frame, so there is no claim for restitution. And I think we immediately agree that this is not a satisfactory rule, because the really important point, of course, is the moment where the collateral is sold by the bank to make money from it to cover the loan. And the rule now says very clearly, if the victim of persecution, due to persecution, was not capable of paying back the loan due to persecution, then there is a claim for this object. And this clarifies the situation very, very clearly and powerfully, and I may say in a way that we argued for in our restatement project. Another constellation is then that the bank is, so to speak, persecuted. Jewish bank receiving collateral artworks, and then is Aryanized, and somehow the objects are lost. And here the rules also say, in such a case where the bank does not hold the artworks as a kind of art, but only as a kind of asset to secure a claim, which may be considered differently, to be different. Even then, there is a claim for the successors, for the partners of the bank who were persecuted, to claim these objects back. And this is, I think, so much more than we had in the practice before, and way more before we had in the black letter rules of the Handreichung. So that's the rules on collateral that are now applying to the cases. Thank you.
Right. Thank you for clarifying. If I may, I have one more question, and that regards your last sheet in recurring questions to wrap up. You posed the question of are the new procedural rules taking care of the special needs of the claimants? In those procedural rules, I don't, and that is a point that Stacy or Professor Jessamine also made, or Carol. It was something about provenance research. You know, In the Netherlands, there is much discussion about the legalization of claims, no cure, no pay basis of or lawyers that enter into such claims on the basis of a no cure, no pay agreement. And there are also claimants who do not have such a lawyer because the value of their artwork is not that high, so it's not interesting to do so. So how are these procedure rules better without any secure securities regarding provenance research and provenance funds? Because that is something that has in the Dutch context, there is provenance research conducted via the procedure before the restitution committee, and that is government sponsored. And much is to be said about the arrangements in the Netherlands, but that is something that is provided to by to the claimant. So,
Thank
have
you
you any
for,
thoughts on that
yeah.
in that regard?
Yes, thank you for reinforcing this point that we addressed a little bit already. Yes, that is a valid point that you are raising. How is the claim financed? How is provenance research financed? Maybe a claimant in respect to an object that is not so valuable, where there is no lawyer willing to operate on a contingency fee basis, should try to go, nevertheless, to the arbitral tribunal. And the expectation is then that the arbitral tribunal will take care of missing pieces in the provenance research, and it will commission specific provenance research tasks. And it is my understanding that these very specific tasks of provenance research, they are financed by the public budget. That is not clearly laid down in the rules, and which I criticize very much for a long time, there is no centralized organization for provenance research in Germany, as opposed to the Netherlands and as opposed in particular to Austria. I would very much like to have such a central provenance research unit available. There was no political agreement on that. Rather, that's the sound I heard from the depth of the discussions. I was not directly involved. The provenance research in Germany did not like so much the idea of centralization. And I think it's still a problem that provenance research mainly is conducted by the current holder, by the museum, financed by the state, financed by the German Lost Art Foundation, yes, but it's still organized by one side. And this is, of course, not optimal. I would plead for a centralized organization. We also advocated for that in our study without success. Yeah, maybe in the future we'll make progress on that level as well.
Thank you so
Thank
much.
you, Jabita, for these very good questions. Neve Goldberg.
Thank you, Matthias. Although I do think that Wesley was before me. So if you want to give him.
I'm sorry, Wesley. On my list, Neve is on top, but I'm fine either way. So I just follow the formal procedural rule of listing the hands
from top to bottom
with everything.
Yes. Okay. Mine is fairly quick, and I don't know if it's so much a question as a comment, but you can, of course, relate to it. When this arbitral committee, the news of the arbitral committee and the beginnings of it came about, one of the things that you and I spoke about were whether the requirement for public bodies to participate would be enough to make this arbitral body sufficient or successful, despite the fact that it does not cover private entities unless they specifically agree. And now we're at this stage where you've noted that there are over 200, I think 201 public bodies that have agreed. of which, if I counted correctly, some 49 or 50 are municipalities only. The rest are either the Länder or the federal government or various organizations beneath them, some of which are museums and some of which are universities and so on. But for instance, I'm taking a look at Hessen, and I see in Hessen there are only 3 municipalities which have agreed, and none of them is Frankfurt, for instance, or any institution as far as I can tell, which is in Frankfurt, perhaps yes. Now, there are over 10,000 municipalities in Germany. Of course, some of these are small, some of these are villages, and some of these are towns, but who knows where, all of these looted artworks are. If this is our state now, what is the real expectation of how this will progress? Because if it's going to take other major cities or many municipalities 5 years to decide to join up, then is this really a framework that's going to work?
Thank you, Neve. That's, of course, a central question. And I can only agree with you criticizing the state of things. That's not what was promised at the moment when the administrative agreement was concluded. The umbrella organizations for the municipalities obliged themselves as parties to the agreement to have the municipalities participate. They don't have a legal means to do it. That's the situation, but they promised to do it and to manage it. And that was kind of the assumption for the whole thing. And of course, we are not in a satisfactory state, but I would say that we are in a way better state than before, even though it's 200 plus something. And yes, not all of this 200 are municipalities. There are different structures, or there are many structures of public owners. So universities are independent owners, so they have to declare themselves. The Stiftung Preußischer Kulturbesitz, for example, a foundation, they have to declare themselves. But very large players have done it. It is the Stiftung Preußischer Kulturbesitz, for example, Klassik Stiftung Weimar, there is Munich, there is Bavaria. Yeah, so there are big players, relevant current holders who participate in this system. And I very much hope that the process will speed up massively in the next few weeks. Absolutely. What would have been the alternative, Nif? That's the question that I think we also discussed a lot. It would have been a very complex parliamentary legislation by the federal level that would have to impose participation in such a proceeding on other owners within the state. And that is a big problem. That is politically a big problem, but it's also technically a big problem. And it would not have been possible to achieve this within the remaining time of the government. Look at other countries who are trying to proceed on the basis of parliamentary legislation. If I may refer to Israel, I mean, of course, Israel has very different and pressing priorities at the moment, and we fully understand that. But it was an attempt to go through parliament for a legislation, and it did not succeed. We see that struggle in Switzerland. It has taken years and decades, and I think 15 attempts to go through parliament. And now, after 25 plus years, we will have a commission that is, let me say that with all respect for our Swiss friends, that will be as weak as the advisory commission used to be in Germany. And so I think it is a possibility to try to get further in quicker time than through parliamentary legislation. Last point, last comment of mine in reaction to your comment. Nothing stops the political level from further pursuing legislation. All of that is now based on the administrative agreement can easily be transformed into a parliamentary legislation. Nothing is excluded by setting up the arbitral framework as it has been set up now. It is even our suggestion in the study. There should be a two-step process, to go further into a legislative framework. I hope this will happen. This would be better. And still, I realize simply the political constraints that may increase in the future in this country as well. And so I'm not happy, but I am content that we achieved a significant step forward, even though there is much to do. That's there remains much to do. That's maybe what I would like to say at this moment. I hope this is somehow answering your comment. Thank you. Wesley, good to see you.
Thank you for your presentation. My question is actually very similar to Mr. Goldberg's, because this business about the termination of the administrative agreement is excluded only for 5 years implies that a given entity, whether it's a lender or a municipality, whatever, can simply wait out the term and then essentially exit from the entire procedure. I'm wondering what sorts of things are envisioned if that actually happens. Will there be an attempt to convince these entities that they should not do that? What happens under those circumstances? It seems to me that this is very much a short-term matter. We're already 80 years or over 80 years since the end of World War II. How long does this go on?
Yeah, Wesley, thank you for this question. You are absolutely right. There is the possibility of termination. It's only excluded for 5 years, and afterwards, with a period of 2 years towards the calendar year end of the calendar year, there is the possibility to terminate. Otherwise, it would not have been possible to conclude this agreement. And of course, my strong expectation would be that the political forces that believe in the necessity of restitution will do their utmost to convince an entity to remain in the system. I think we all think about states somewhere in Germany who might be governed by unwanted parties in the near future. I'm not mentioning anything particular deliberately, and I hope that is not going to happen. But if it happens, it does not destroy the whole thing. It only removes one entity and the others remain bound. That's at least something. Yeah, that's at least something. And if you compare it with the situation that we would have under a federal act, a restitution act, that's what we all call for as the ideal form. Yeah, but we are not getting to it. That's the reality we are facing. If we compare it with the stability of a federal restitution act, I'm not sure whether the act would be more stable. Once the parliamentary majorities change, this federal act will be overturned in days. Yeah. So it is an illusion to say that parliamentary legislation would stabilize the whole thing. No, this is not the case. And my positive theory, my hope would be that this arrangement, contractually based between the entities of the state, might be more resilient in these times than such a one-piece federal legislation. And of course, we do expect the federal government to come up with federal legislation in relation to private owners. This is promised in the coalition agreement, and we hope to see it soon. Yeah, and we need it in this respect because constitutionally it's not possible to do it differently. In our system, it is possible to do it differently for the public owners because all the public owners decide themselves about their own property, and that makes the things easier technically. Does that somehow reply to your concerns?
Well,
what is your suggestion, Wesley? What is your suggestion?
No. Well, the suggestion is undoubtedly not not reasonable. The observation is that all of this looting was taken under centralization, the strongest of centralizations of the country, and that under the circumstances, this attempt to try to reverse it is very weak in comparison. But it's better than it is.
Yeah, I know, and you are right. And nevertheless, that's the overall structural situation we have to operate in. And it is so difficult because federalism has been made so strong in response to the centralization and the alignment under the totalitarian regime of the Nazis. And now we are seeing impediments that we would not wish to see for moving forward. I'm not justifying that, but I'm simply trying to explain why it is maybe more difficult in a federal state to move forward in this respect, where 80% of the cultural objects are held by the municipalities, other than in Austria, where most of the objects are held by the federal level. And Netherlands, that's a unitary state, so it's very easy, not very easy, but it's easier, technically speaking, to set up an overall framework. And given these constraints, and Wesley, I think you know these constraints from the United States of America, the constraints of federalism, but also the chances to resist totalitarian tendencies through federalism. We have to accept that and make the best out of it. Yes, there is still lots to do.
Thank you.
Thank you, Wesley. Camille Zeidler. Are you still there, Camille?
Yes, I am. I'm trying to turn on the camera. Is it okay? Yeah.
I can see you. Fantastic. Oh. Good to see you.
Dear Professor, dear Matthias, my dear colleagues, what I want to say, first of all, I want to say that I'm impressed with this important initiative and the legislative legal action, because it's better to have something than nothing or almost nothing, and it's always better to do it later than never. That's why we should all appreciate the actions established by the German government, especially efforts which our colleague Professor Weller did in the case, and we perfectly know what he did for the last few years. What I want to say that from the Polish point of view, I have to unfortunately emphasize that in Poland we do not have any systemic approach to the subject of cultural property restitutions. Of course, during the Second World War, Poland was a victim both of the Nazi Germany as well as Soviet Union and the Red Army. But after the end of the Second World War, the times of communism when the times of the communism was established, and after that, today we do not have any opportunity to do it in such a way like we can see in this proposition which is presented today. So, to summarize, let me say that this initiative is very important because this is the great example how we can deal with the past and how we can try to face the hard cases in law which have been established, even as you, Wesley, said, 80 or even more years ago. And the last thing, as we perfectly know, is the question of post-colonial restitutions. So piece by piece, we can build this building or this palace of justice, just going from one case to another. And from this point of view, I'm sure that this Court of Arbitration for Nazi-looted cultural property is an important step in on our way. Thank you very much.
Thank you, Camille, for this comment and for also the appreciation. I know that you are doing absolutely outstanding work towards just and fair solutions in Poland under difficult circumstances, sometimes political circumstances. And I very much appreciate that you are a kind of central point, if I may say that, in Poland for our topic. And I mean, if I develop your thought further, a structure like this one that has been set up now here in Germany would be perfectly available technically in Poland as well. By the way, for the United States of America in particular, as they are a federal state as well. And one of the arguments I always heard, why do the US don't have a panel, don't have an alternative dispute resolution mechanism? Why do they send their claimants to the state courts? One of the answers was, well, we are a federalist state. We would never get the yes from the 50 states. We have the same problem in Germany. And one answer would be a structure like the one here. And maybe not all the 50 states of the United States would participate. Maybe it would not necessary to improve things that all of the states participate. And I can only agree if you say it's better to have something than nothing. And that's exactly the spirit, in a way, that we were operating. And I'm convinced that we do have quite something in comparison to what we had before. Thank you, Camille. Are there any other questions, comments? That is not the case. Thank you for staying with us for such a long time. I have a few things to mention if you would still be willing to stay for a moment. No one is obliged. It's late in the evening or wherever you are on your time scale, but I would try to finish with a few points that I prepared for sharing with you. Let me at least mention that our 5 years project, the restatement of restitution rules for Nazi confiscated art, 1,228 pages, a comparison of 6 jurisdictions, the practice of all these states that established a panel like the advisory commission, are compared and transformed and distilled into black letter rules and comments. And I think this might be interesting for all of you as a source of reference. You can see here the main book, so to speak, on the left side, the underlying PhD thesis on the right side, and maybe most interesting for you, it is open access. And you can download the restatement, the entire 1,228 pages, behind the link that you can see at the bottom. We are preparing the English translation at the moment. This is not easy, I can tell you. We are doing our best. It takes a little bit of time still, but I am confident that we will come out still in 26 with the English version. And I cannot mention this without presenting to you, at least for a moment, with all my pride, our wonderful researchers team who contributed to establishing this foundational work of analysis of the practice of Nazi looted art restitution. Further events are upcoming. The one that I'm allowed to mention, even though it's not yet public, is one at the Université de Paris, Panthéon-Sorbonne, et la Fondation des États-Unis. There is a colloquium on Nazi looted cultural property on the 26th of March 2026 in Paris. Somehow, I hope you will stay tuned or try to follow things. Another event that is coming up, and that's, I think, a very important event, is the biannual conference of the German Israeli Lawyers Association, the Deutsch-Israelische Juristenvereinigung, DIJV, DIJV. I have the privilege of being a member of this association, and I'm also very, very pleased and happy to present at this conference in Tel Aviv and Jerusalem between the 10th and 17th of May on the Court of Arbitration for Nazi-looted cultural property. So should you be in Israel and should you have the time, make sure that you are part of this continuing discourse on the subject matter. As of today, 28th January 2026, the members of the Swiss Commission on the so-called historically tainted cultural property have been appointed. If you are interested, you can see the list of members behind this link. And as I mentioned before, the slides and the recording, as well as other materials relevant to the topic, will be available soon at my chair's website. There are two sub-pages, one on the restatement and one on the reform of the Advisory Commission. Last not least, there are a few texts in the pipeline. There is one of mine coming out in Justice, the Journal of the International Jewish Lawyers Association. I'm very grateful that I was asked to say a few words on the Court of Arbitration for Nazi-looted art in this journal. There will be an article of mine in the Neue Juristische Wochenschrift soon in spring 2026 in a special edition on art law. And there will be the conference proceedings of the University of Basel's conference back in 2025 that will come out soon. And there is also some input of mine on the Court of Arbitration for Nazi-looted cultural property. Well, that was it from my side. Thank you so much for staying so long in this video session. I wish you all a good evening, good morning, good afternoon, and I hope to stay in touch with all of you. There are many things to be done ahead of us, and there are things that have been achieved but need to be evaluated and improved. And I invite you and hope for your input and support in this respect. And I hope to see you soon at the next occasion in this discourse. Thank you very much for being tonight in the session.
Komme ich denn da jetzt raus? Wie komme ich denn jetzt? Da.